Hello, Namaste. This is Citizen Zero of India. Today is the 27th of July 2026, a Monday. Regarding this video statement, on behalf of a petition under Article 32, a writ petition under Article 32 of Constitution of India, being filed at the Supreme Court of India since May 2026 by the petitioner and citizen of India, and yours truly, Samir Nandan, a son of late B.L. Himavati and H.P. Damodar. The reason Citizen Zero of India is discussing this petition in this video is because it is both a personal as well as a public cause. It concerns not just this individual, as myself, but also something that affects at least 500 million or more citizens of India who may have had to open bank accounts, online bank accounts, zero balance bank accounts in the last 12 years. Therefore, I'm taking this opportunity to discuss what this petition is about. So this petition concerns, as I mentioned, a citizen of India, Samir Nandan, versus respondents, Reserve Bank of India and its integrated ombudsman scheme, and a public sector bank concerned right now, in this case, the Canara Bank and its chairman managing director, as well as its local branch manager. The issue pertains to the early withdrawal of a fixed deposit in a public sector bank held, in this case, which has been denied to its customer. And it has been denied even at the instance of the customer facing bankruptcy and extreme hardship. So the petition is being filed at the Supreme Court under Article 32. Or it could be filed at the High Court under Article 226. But because of the e-filing procedure, the convenience of it, the petitioner has gone ahead and filed it directly in the Supreme Court, and possibly because of the importance that it affects many more people, that it would be best to get a binding ruling that cannot be challenged in any other courts after that. Therefore, I wish to discuss this petition for the Office of Citizen Zero, which is our journalistic platform. So, before we discuss what the petitioner has placed this petition in a public domain repository for the benefit of others who may, including all the personal information, personal documentation, those who may be experiencing the similar situation. So I will avoid mentioning the details of any names used in the petition, but in this particular video for discussion of the actual case itself, so we can actually get to what the constitutional issue at stake is. So the video statement is being recorded here by the petitioner in person because the petitioner feels the determinants, and additionally because of the state of bankruptcy, the petitioner is incapable of hiring actual legal representation. So the petitioner in person, however, feels the determinants of the basic facts in this case at the very natural outset stands to entitle the petitioner for receiving a payment of damages for financial loss as well as personal harassment up to 20 plus 1 lakh respectively, as per the cursory guidelines given by the Reserve Bank of India Ombudsman filing procedure, the complaint filing procedure. But this is in addition to what the petitioner may be entitled to receive as a payment for other damages, which is to be duly assessed by the court, by the Supreme Court, from the threat arising in this case to the violation of the fundamental right of a citizen of India to one's life, liberty and livelihood enshrined in Article 21 of the Constitution of India. And this is the main constitutional issue that's tied to this financial issue, of this financial solvency issue that we are trying to petition for. I mean, the petitioner here thereby also wishes to use this video solicitation because of his state of penury to seek affordable legal representation in India for litigation of this petition at the Supreme Court on behalf of the petitioner in absentia arising from the current difficulties in the petitioner's health and financial circumstances and its continued deterioration while the matter is being decided by the courts, and while those public institutions, the banking institutions, continue to maintain their denial of service and communications with the customer. And as this is therefore, this petition is barred by the time constraining upon the life of the petitioner, and for this purpose has willingly provisioned out of whatever aforementioned damage payments which the petitioner is duly entitled to receive a legal allocation fee of 10% to any senior advocate at the Supreme Court, who, upon the condition that he or she is able to duly represent and litigate this case to its completion and secure an eventual result in favor of the petitioner, unless, of course, the Honorable Court themselves assign the services of an advocate on record in the matter, and the petition filed by the petitioner may proceed in if the petitioner is unable to present himself in absentia or to complete the requisite filing procedures on the importance of the case. From the difficulties of the current circumstances, from the multiple attempts of the petitioner in person at self-filing this petition at the Supreme Court, the current petition and the supporting document as prepared has been as prepared by the petitioner in person himself, and is determined as may be needed by any legal representation in this case, and all of the documentation which can possibly be provided by the petitioner in person has already been included here and placed publicly in an online repository included in the web links in this video. And the petitioner in person states that while he has filed this petition already, tried to file it 3 times, and has tried to organize the petition as per the format of the templates. I mentioned templates because provided by the registrar of the Supreme Court in their email exchanges, after which the email exchanges have stopped. No further communication has been maintained. The registrar of the Supreme Court, after the first filing, sent a plethora of documents, about 10 or 15, 12 documents, and requested the petitioner to organize a single document into an order based on those 12 different documents. And the petitioner had been able to do that, has been able to paginate it, as they say, as the word they frequently use for any defect in the petition. The registrar's main defects that the registrar finds is the order of pagination, which is the page order. So the petitioner has been trying to organize the pages as many orders as possible, and as determined with the help of artificial intelligence as well. But the petition, the affidavit, and the facts of the case, they have not been examined. It is very straightforward. It is a bit of a Kafkaesque situation where the case is not being presented before the judges because the actual filing procedure itself is a little obfuscated. The petitioner has been struggling to get right, and this has caused about 2 months of delay just to get this up in the air, in which all this time the petitioner is in a state of penury and frugality and facing whatever kind of deprivation, physical and healthful deprivation. Now, so additionally, so the petitioner in the e-filing procedure came to realize that the petition could be filed as a civil petition or a criminal writ petition. Now, obviously, no one files a criminal writ petition against a bank unless the bankers carried guns with them, and I do not know that happening unless wars are being carried out in the world. So the petitioner, however, could not file it as a civil writ petition because it costs 500 rupees, and the petitioner is in a state of bankruptcy where has almost no money left in his bank account. So he went and filed this as a civil writ petition, as a criminal writ petition, claiming that the action of the banks directly threatens the life and liberty of the petitioner by infringement and violation of Article 21 of the fundamental right of the Constitution of India. Therefore, since it's a criminal writ petition, the petitioner has made it has intended that this video statement should also serve as an electronic and zero FIR that can be registered at any police station in India who would be willing to take due action for the protection of the life and liberty of the citizen from the inaccessibility of his monies withheld by the respondent bank, here the Canara Bank, and under the disputed Reserve Bank of India guidelines. Now, the petitioner wishes to say, however, that if it is not possible, the postscript is that the petitioner says if it is not possible in this time to file this petition in the Supreme Court of India because of these procedures, of the delays in these procedures, or unable to secure legal representation after the petitioner has emailed a couple of lawyers to take up this petition, and the senior advocate to take up this petition on his behalf, since he is unable to open channels of communication, he feels that in the case that in the event that this petition cannot be filed, and in the event of facing death, the petitioner wishes that the holder, as the holder of the disputed fixed deposit, that he cannot, and since he cannot either withdraw or change at this moment, to select a nominee for this deposit, and which is not a large amount. So we'll go through the details soon. The nominee to be a Teach for India organization as an alternate nominee for the settlement of the amounts to be released from this deposit towards its use in government school programs in the state of Karnataka. And so this is the petitioner in person's just a few statements he had to make prior to the discussion of the facts of the case. So this summary explanation of the writ petition as addressed to the Honorable Justices of the Supreme Court now follows in this video. Thank you for tuning in, dear citizens of India. Let's see. So, as I mentioned, I'm Citizen Zero of India. This is the 27th of July, 2026, Monday. And we are discussing a petition filed by the petitioner, Samir Nandan, alias Sam Damodar, son of B.L. Himavati and H.P. Damodar, aged about 43 years, residing in Bengaluru, having filed a criminal writ petition under Article 32 of the Constitution of India and the Supreme Court of India for extraordinary jurisdiction in the year 2026 versus respondents, Reserve Bank of India, Central Office in Mumbai, Reserve Bank Integrated Ombudsman on the Internet, which is found at the website www.cms.rbi.org.in. The Canara Bank, which in Bengaluru, the head office, and its branch manager, the local branch manager, to which the petitioner has an account with. So this is some of the details of the case. The petitioner seeks an issuance of writ in the nature of a mandamus, order, direction, or any other appropriate writ for the violation of fundamental rights 19(1)(g) and 21 of the Constitution of India of life, liberty, livelihood. So just getting to discuss the facts of the case, as the petitioner has placed this petition in the public depository, as mentioned to the Honorable Chief Justices and the companion justices at the Supreme Court of India. The facts of the case is this. The petitioner is a citizen of India presently, residing at the address stated in the petition cause above, and as a retired individual dependent entirely on the inheritance The petitioner is a citizen of India presently residing at the address stated in the cause title above and is a retired individual dependent entirely on the inheritance bequeathed by his parents and for maintenance of his living expenses as shown in his financial statements, which is aged 43 years, which are not falling within any tax bracket in India, and consequently owing no income tax whatsoever to Government of India, is hereby constrained to approach the Honorable Court under Article 32 of the Constitution of India due to the arbitrary, disproportionate and mechanically administered actions of the respondents, the Reserve Bank and the public sector bank, Canara Bank. So the petitioner, some of the facts of the issue at stake is that the petitioner says he's maintained a savings account with this bank for nearly 30 years at this branch, and while operating a net banking app, Canara AI1, had opened a paperless deposit for a greener tomorrow. That was the advertised pitch by the app, and this deposit turned out to be a tax-saver fixed deposit, which the petitioner unwittingly signed up with, bearing a deposit particulars as follows. As we mentioned, it's not a large amount. It's only about 1,50,000 rupees. And the deposit was opened on 13th May 2023 with a maturity date on 13th May 2028, that is 2 years from now, at an interest rate of 6.7%. The petitioner could not, after opening the deposit online, could not liquidate the deposit online. The feature would not allow him to do so. So he could not withdraw the deposit. It was locked in. Supposedly, subsequently after that, owing to financial hardships and imminent bankruptcy circumstances, an absence of sustainable income and urgent subsistence concerns, the petitioner approached the respondent bank, the Canara Bank, multiple times in those last 3 years. From the time of opening that, he approached the bank directly, requesting one of these things: all of these things, in fact, premature liquidation or withdrawal, closure of the said fixed saver deposit, of a manual injunction to remove the automatic hold placed on it by the app, since this feature has been rendered inoperable with the phone app, and alternatively, in lieu of that, a grant of a personal loan or an advance against the forced deposit placed as collateral security with the bank. So, in both cases, the petitioner has approached the bank about this matter in the 3 years, but very recently, when this appeal procedure began last in February 25th, 2026. These dates are important because the appeal procedure with the Reserve Bank measures the time of the last communications that the customer has with the public sector bank to determine its ombudsman adjudication procedure. So on 25th of February 2026, when the customer approached the bank, they rejected the request of this petitioner of the customer once again, and asserted, as usual, the deposit could not be used as a collateral for obtaining a personal loan either, and stated that the premature withdrawal was not allowed, except, and here they made a very bizarre statement. They said only if the customer had a death claim settlement, in which they would allow a early withdrawal of the deposit. Now, to the petitioner and the customer at that time, this sounded oxymoronic. He said, how can a dead person make a claim for an early withdrawal of a deposit? They said it's their nominees can make a claim for such a deposit. Now, the petitioner said, this is my personal funds, I don't have a nominee. How does this make sense? Isn't this an implicit, he said, isn't this an implicit threat to the life of the customer? That they're saying this, a deposit can only be liquidated if the customer himself dies. So they refused, when the customer said, can you please provide policy details of such communications in paper statements that can be produced at the courts or to the ombudsman, the bank manager refused. He said, we don't have time to produce these communications. This is what it is. The customer insisted that he needed communications it's almost like visiting a bank and being told to go away, and that visit never happened. So finally they yielded. The bank asked the customer himself to write a letter in front of the bank manager, not once but 3 times. Once on the 25th of February, and then twice in subsequent visits up to March 7th. In each visit, in the first visit, was asked to write a full page of the communication that had taken place between the manager and the customer about one, that this is a tax saver deposit, it cannot be liquidated. 2, that the second letter, the tax saver deposit cannot be used as a collateral deposit, a collateral security for a personal loan, and that the loan was to be rejected because the customer was not a salaried individual and was living off the inheritance of his parents. And thirdly, the bank had made a statement that the customer can retrieve this money, I don't know how, upon a death claim settlement. His nominees can. So all these 3 letters were handwritten by the customer from the communications with the manager on those visits, and it was sealed and signed by the manager and the bank on behalf of the Canara Bank. which almost amounted to a state of harassment. After the customer really just said, just give me printed bank policy details on this matter. So in this obfuscation and denial of communications and information, the respondent the petitioner then appealed to from the branch manager to the head office. Appealed to the branch manager to provide email communications as well. Even that was ultimately there was denied, and finally when they did email the customer, they dispatched instead of a printed bank policy detail, an incoherent paraphrased single line email notice of the supposed bank policy of tax saver fixed deposit bank policy by Canara Bank, stating it was RBI guidelines that mandated them to behave in that manner. And so the petitioner then the customer took this issue and emailed the head office as well. No response from the head office nor from the bank manager thereafter. So at that incommunicado, the petitioner went ahead and opened a case with the Reserve Bank of India Ombudsman on the website. Since they said the last issue that the bank mentioned, the Canara Bank or the public sector bank said it is mandated by RBI guidelines. Therefore, the Ombudsman, the filing procedure was halted, was prevented initially, had to wait for 30 days from the time of agreed thereby the petitioner attempted to file a complaint with the Reserve Bank in its Ombudsman scheme of 2021, and he was required to wait for 30 days for the entity's reply, respondent, the public sector bank's reply before filing a complaint with the Reserve Bank of India, and could not proceed further at that point. And upon no further responses from the Canara Bank and the respondent bank, the Canara Bank's manager and the head office for a whole month, the petitioner later reapproached the Reserve Bank Ombudsman scheme and obtained a filing complaint number RB IOS N 2026-27 002 002 So that was in the end of March 2026, after the last complaint with the bank. The Ombudsman later, however, closed the complaint. The Reserve Bank of India Ombudsman closed the customer's complaint under Clause 16(2)(a) of the Reserve Bank of India Integrated Ombudsman Scheme 2021 by observing that there existed no deficiency in the service by the regulated entity, its regulated entity being the respondent bank, the public sector banks, Canara Banks. What did they mean by no deficiency in service? The Reserve Bank of India meant that the Canara Bank's denial for closure of a tax saver fixed deposit early withdrawal, their denial of that closure, their denial of lending a personal loan with that deposit as a security of the same amount, and the idea, whether they entertained the idea of a death claim settlement for such a deposit for early withdrawal, that all those denials were considered to be no deficiency in service. And when there was no deficiency in service, the Integrated Ombudsman Scheme of the Reserve Bank of India closed the communication and made it non-appealable. The customer could no longer appeal to the Reserve Bank of India for any remuneration on the matter. So the petitioner respectfully then had to submit the case to the Supreme Court because the Ombudsman order at the Reserve Bank has now become non-speaking, mechanical, procedurally unfair, entirely failing to consider any documented hardship. They did not even ask for documented hardship, saying you're going to the customer, if the customer was going through any hardship, bankruptcy, financial statements, nothing. They just blankly closed it, shut it down. They did not determine proportionality. They did not make any time-sensitive discretion that the person may be enduring penury and deprivation from the time of the filing procedure. And clearly, everyone missed this point from the constitutional implication arising from an implicit threat to Article 21, the fundamental right to life and liberty of a citizen of India. So the petitioner has brought this case before the courts as a petitioner. He has to get through the registrar. After Kafka gets through the registrar, we will have the trial. And then, until then, he's going through the metamorphosis, he wakes up one day and finds out that he's turned into a creature, 6 legs. He's hanging upside down on his back, and he's staring at the ceiling. So the petitioner respectfully submits to the High Court here, the Honorable Supreme Court. That on account of the state of penury and immobility arising, state of penury, bankruptcy, and immobility arising from the aforesaid endangerments to life, liberty, and livelihood, the petitioner is unable to even secure the services of an attorney for attestation for filing this petition at a senior advocate, and the last bit that remains to get it notarized, and arising from also, and therefore also mentions that the citizen, the petitioner, files this petition as a criminal writ petition and not a civil writ petition, because the e-filing procedure is free of charge for a criminal writ petition, whereas it costs 500 rupees for a civil writ petition, and based on the infringement of the threat to life and liberty of the petitioner. This is what. Now, what is the question of law? These are the facts of the case that we just discussed. Now, what is the main question of law that the petitioner has raised in this petition? The first question is, can a public sector bank and the Reserve Bank or any Reserve Bank of India regulated authority apply such financial restrictions in a wholly inflexible and a mechanical manner without consideration of the documented hardship of bankruptcy of a customer, not just an audit of a customer who's been there for 30 years, let alone even for an ordinary customer, meaning anyone who just opened a bank account. Now, whether or not, this is one question. The other, whether or not the bank's refusal to consider alternative secured lending, a loan against the petitioner's own deposit as a security, an assertion of the feasibility of a premature withdrawal only in terms of a oxymoronic death claim settlement, and its unavailability otherwise upon the petitioner's hardship, is arbitrary, unreasonable, and predatory in nature, and also violative of Article 21 of the Constitution of India. This is the main question of the petition is asking. This is the main issue. The other main issue is whether or not such a case pertains, whether or not this petition can serve as a precedent against the endangerment from institutional malingering, information denial, and obfuscation, and technology bottleneck of these public sector banks from their recent endangerment to 500 plus million Indians who were enticed into opening online zero balance bank accounts with these banks in the last 12 years, And in signing up with such online, enticed with signing up with such online banking services offered by these banks. This is the other main question. And so, what are the other grounds? Those are at least the three main questions, and and the other one is a question of jurisprudence, whether a complaint procedure like the ombudsman can make the procedure non-appealable and whether it violates principles of natural justice, procedural fairness. So the petitioner, the grounds. So what is the petitioner providing here? The documentation. The petitioner establishes the grounds of hardship based on increasing frugality of his living expenses over the last 3 years, and without being able to avail the full utilization of of his own fixed deposits, and facing the current bankruptcy, from the fact of having less than 10,000 rupees remaining in the bank account at the time of filing of this petition at the Supreme Court, and currently half of that, and from the unavailability of any other means of financial support for him at this time. So he has provided the documentation of his hardship situation to obtain his own deposits back, to obtain his own the money in his own fixed deposit. So let's see what else. The petitioner demonstrates the ground for institutional malingering and abuse of office of the public sector banks through denial, non-notification, obfuscation, and delays in the nature of communication maintained with them, either on personal visits as well as online correspondence on the above issues, carried to the point of causing imminent endangerment to life and liberty of the citizen. This is the thing. As an individual, to prove that even communications happened with the bank upon any direct visit, or in case of online procedures or emails where no response is received, the customer is at a loss to prove any communications even happened. So, and if that is so, how can he or she bring this case forward to the courts? So that is the ground. So the petitioner here has taken the pains to document the existence of non-communications between the customer and the banks, and denial of service through these procedures. That forms part of the proof, the documentation placed in this petition. So ultimately, what is the issue here? The main issue, as far as a constitutional issue concerned here, is in the averment. The petitioner thus avers that without the swift and immediate access to the remainder of his own monies kept in the said fixed deposit in the bank, he faces a life-threatening situation day by day, unable to even leave his residence over these last 3 years, at the risk of ordinary, unforeseen consequences of unaffordable, uninsured living in India, and thus signaling a danger to light upon the Constitution of India and its ability to protect the life of a citizen, life and liberty of the citizen of India through Article 21, the fundamental right of a citizen. So this is the information that the petitioner has provided in this petition. So thus has not filed any other petition in the Supreme Court or any other court in the matter of this present petition. The main prayer under the facts and circumstances of this case stated here and above It is most respectfully prayed that the Honorable Court may graciously be pleased to issue a writ of certiorari quashing the impugned RBI Ombudsman closure dated 28th May under Clause 16(2)(a) of its RBI iOS scheme, 2021 scheme, and issue a writ of mandamus directing the public sector bank, the Canara Bank here, to reconsider the petitioner's request for early withdrawal of the deposits in a reasonable, hardship-sensitive or a bankruptcy-sensitive manner, to direct the banks to either for the early withdrawal or to consider the feasibility of secured loan against the petitioner's own deposit, and for the courts to avoid to determine the necessary compensation and costs for this kind of arbitrary administrative conduct and the resulting hardships borne by the petitioner, and to pass any such orders as the Honorable Court may deem fit, proper, in the interest of justice. And for this act of kindness, the petitioner shall, as in duty bound, ever pray. This petition is being attempted to be filed since May 2026. The petition was last rejected on 29th June 2026. It was refiled on 9th June and 23rd June 2026. So after 3 resubmissions, it has been rejected for defects by the registrar. We've organized this petition to the format to the best of its best of our knowledge, but without free paralegal aid, it would be it seems a little it seems very Kafkaesque with all the different documentations that were provided, but it seems to be good. You can have a look at it. Therefore, he's appealing for. This is also a video solicitation for a senior advocate to take a look at this case. So the petitioner wishes to conclude saying no part of this petition or affidavit is false, no material has been concealed thereof, and the petitioner in person does not represent any government authority for any relief claimed in this petition, nor has he filed any other petition in any other court. So this is basically the synopsis of the case, which goes through the facts and the grounds of the case and the list of dates. Important list of dates, beginning from 13th May 2023, when the deposit was opened, to the beginning of this year in May 2026. In February 2026, when the banks once again refused to consider the hardship and bankruptcy and the appeal procedure beginning from 7th March 2026 and to currently July 27th, 2026. So almost 6 months has elapsed where a customer has remained in a state of bankruptcy and physical deprivation before the courts, and the banks have maintained non-communication, and the courts are going through the filing procedure. So this is the lapse of the time. So all those details are there in the petition. So I do not wish to make this an act of an exercise in pedantry, reading through all the details. So documentation included, all the annexures, the copy of the fixed table deposits, the copy of the communications issued between the banks and the customer, all the denial of loans, the hardship representation, financial statements in the last 6 months, last 3 years, also the hardship information, finally the RBI communication, the ombudsman complaint, etc., the non-appealable complaints, all the documentation has been placed in the annexures in the petition. All this information has been placed by the petitioner, organized into a single petition and placed in an online repository, included in the video links, on whose behalf I, Citizen Zero of India, am making a video statement as a matter of public interest that it concerns. This is on this day, the 27th of July, 2026, Monday, last week of this month. We thank our listeners for tuning in for Citizens of India. And okay, that's all, folks. Vande Mataram. Jai Hind.